Okay, I think I'm going to go ahead and get started. And people can continue to come on. Again, welcome to our webinar today. I'm really excited about having a session on intellectual property. So if that's what you are expecting, you've come to the right place. However, before we get started with that session, I'm going to give you some information about SCORE. I will tell you that you will receive a copy of the slides and a link to the recording. If you have comments or questions, please use the chat or the Q&A, and we will try to get to all the questions. Okay, so again, SCORE is a national organization. Our mission is to foster vibrant small business communities. We do this through mentoring and education. We hope that every person and you as a small business owner get the support that you need to be successful. Small business drives our national economy and certainly our local economy. If you have noticed over the past few years, downtown Cleveland is being revitalized through addition of small businesses. So you are a very important person to our community. We have the largest network of free volunteer small business mentors in the nation. And no matter what stage your business is, we can find a mentor for you. Again, if we have somebody in the Cleveland office or in your local SCORE office who is not able to find a mentor that meets your industry background, they can search the database, and there are 10,000 volunteers across the country. We're bound to find somebody with the right background to be your mentor. So you can easily request a mentor by going to our website. And again, whether you're starting, whether you've been in business and you want help growing your business, or even if you're thinking of selling or retiring, we can help you with that. This is a picture of the volunteers across the country. You can see they are absolutely everywhere. We have a code of ethics that tells you that your data that you share with us is safe. We will not share it with anybody. We are not committed or permitted to make money in any way from it. And we can't use it for commercial reasons. So you can be confident that your data is confidential and protected. This is a snap of our website. If you go here to local mentors, you can sign up. You have a choice of actually browsing the mentors and choosing the mentor that you want, or you can allow us to match you up with somebody. We have a list of all the upcoming workshops and webinars, and also a database of about 80 to 100 recorded webinars. So if you don't have time to attend one of our live webinars, you will find perhaps the same one recorded within a week after the workshop occurs. So here is a QR code for our website and also the URL. So I am going to stop sharing here and turn it over to Michael Steele, who is a patent attorney, and I will let him tell you a little bit about that. But I will also say I've watched many IP webinars, and I think this is the one that is best for our entrepreneurs. So I'm really excited about watching Michael's presentation. So it's all yours, Michael.
Okay, thank you. Well, as Anita said, my name is Michael Steele, and I'm a patent attorney. Today, we're going to have the agenda. We're going to talk about the major types of IP. I'll give you as many examples as I can, and we'll have some time for questions. So we'll make this real quick. This is just a bit about my background. I've been working for the Tiroli law firm in downtown Cleveland since 2004. Actually, while I was still in law school, and I became a partner there at the end of 2011, and I've been working there ever since. I have a particular experience in drafting and prosecuting software and electrical patents. So, apps for phones, servers, that sort of thing, as well as chips for controlling power supplies and various other devices that for circuits and that sort of thing. So those are like my two biggest areas, and I have some other sub areas as well. But this isn't really about me, so I'll make the intro of myself and my firm a little short here. So the first question you have is, why do you even need IP? So, what value does intellectual property have? And I remember thinking about this question, and I came across this movie from when I was a kid, The Princess Bride. And there's this really funny scene where Carrie Ewells, who was playing Wesley and the Dread Pirate Robert, says, "No one would surrender to the Dread Pirate Wesley." And what scheme that they had come up with was he was actually using the name Dread Pirate Roberts and all of their paraphernalia with their logos and that sort of thing, and basically getting ships to surrender just on the name. And that shows you the value that you can have just with a name and slogan. As evidenced by when you hear Peyton Manning did those commercials of where he would hum the jingles for Nationwide, and just hearing the jingle made you think of that company. And there's an actual monetary value associated with being able to use that name and likeness. And that's the fundamental thing about intellectual property. When you've done the work, the research, and the marketing in order to get your product known, or you've done the engineering to develop a product, it's basically what they're saying is it's not fair if you just somebody else just gets to use that name, that product, or whatever without paying you a license. And that's the fundamental concept of intellectual property, and all of it stems from that concept. But it's just important to understand why IP is fundamentally so important to doing business. So there are four major types of intellectual property, and we'll cover each one in some detail. There are trademarks, copyrights, trade secrets, and patents. And a lot of people don't always understand the difference between each one. And quite frankly, a lot of that stems from the fact that many times you can have the different types of IP cover the same thing. Mickey Mouse is covered by both copyright and trademark. The mouse ears themselves are trademark, but like the individual works like Steamboat Willie was covered by a copyright. So, a lot of times there's crossover between the areas, and that makes it even more confusing. So to kick things off, one of the things that I like to talk about is the different symbols for IP that are out there, and because you'll see these on various products, and it's not always clear what they mean. So the TM mark means a common law trademark, and we'll talk about that in a little bit. And then Circle R means a federally registered trademark. So these both mean trademarks, and one just means that you haven't registered at the TM, and Circle R means that you have registered. SM is called a service mark. It's really just another word for a trademark, but it also means it hasn't been registered. The copyright the circle C is like a copyrighted work, like a book, or something like that. The circle P represents a sound recording that you're asserting is a copyrighted work. And then I came across the circle U on an A1 bottle, and I had never seen it before. And it's really not an IP symbol; it actually just means kosher. So if you see one of these symbols out in the wild, now you have some idea of what they mean. And I get the big question a lot of times is why is there a TM and an R? Now hopefully you can remember one's registered and one is not, but they're both for trademarks. So let's talk about trademarks first. What does a trademark cover? A trademark covers a slogan, logo, or trade dress. And the most important thing to understand with trademarks is trademarks develop from use in commerce and not from filing. Basically, just because you register a trademark and if you don't use it, it's not going to be protected well, unlike other areas of IP. Like, this requires that you use it actively in commerce and people start associating the logo or the name with your particular brand. The trademarks are very important to distinguish your product and service and establish goodwill in the stream of commerce. And it's very important to understand that trademarks, the reason why we enforce them is to not protect companies, but to protect consumers. They don't want somebody to falsely be able to create this loose affiliation with a company that they actually have no affiliation with whatsoever by using the same name or something, or just one word difference between a different organization and yours, and be able to basically benefit from the other work that has been done by the parent company that actually owns the trademark. So the number one question I get about trademarks is, should you register a trademark? The short answer is eventually you should register a trademark, but it costs money. And when you're dealing with entrepreneurs on a shoestring budget, that might not always be in the cards. So the factors to consider if you want to register your trademark or not is to determine if you're letting somebody else use your trademark. And what do I mean by that? I get a lot of questions from SCORE when people have started some sort of a teaching company, for instance, and then they're hiring or contracting with individuals that are allowing them to use the teaching materials. And so then it's very common in that scenario that you'd allow them to use the teaching materials and put your logo on like their business card or something like that. And in my opinion, this isn't a bright line rule and certainly not a perfect test, but my rule for a general guideline is if you are letting somebody else use your trademark and you're not controlling 100% of the use of your trademark, it's definitely time to consider registering it. Because if somebody else is putting it on their business card, what invariably will happen is they might change the logo a little bit because they like a new coloring scheme or something, and you need to be able to control the other usage of that. And it's definitely better at that point to register it. When you can save money and not register it is when you're basically just getting started and it's really just you and you're printing all the materials or creating all of the websites that is using your trademark. You're not allowing anybody, no one else is actively using it. And the advantage, of course, to not registering a trademark is amazingly, it's free to establish your trademark. All you have to do is start putting the superscript TM every time you want to use what you're claiming is your trademark. It's very important you put it on all of your materials, whether it's printed materials on the website or wherever, because you're trying to tell the world that you own that trademark. That's pretty important. So when you have a new product or a new name of a company, put the superscript TM on your business cards, your letterheads, and your websites everywhere. And then if you can start getting money from them and you get a revenue stream, then you can consider filing that trademark. And then you'll switch it from a superscript TM to a circle R. And again, going back to what I was saying earlier, strength of trademarks come from use, not from filing. So actually, sometimes if you're trying to trademark something and is using a very common name, after you establish your use of it, you can actually use that as evidence when you try to file it that you're known for that. And the best example that I'm aware of is when Ohio State managed to register the trademark for the word "the." And in their case, it's extremely limited, as you can imagine, and it has to use particular colors and a particular font, but they were able to establish that use of that word so much in commerce before they tried to register it, that they were able to show that people did really associate the word "D" with Ohio State when it was presented in a particular way with particular block lettering and in a particular color scheme. So to understand trademarks, and throughout all the IP, I'm going to try to be giving examples as often as I can. And the big test for if somebody infringes your trademark is to determine if there's a substantial likelihood of confusion. And what that really will come down to is when you see the trademarked product or the trademark itself and the infringing product, does it instantly register as clearly being affiliated with each other? Are you using enough of the trademarked product or logo that a reasonable person would assume that you are that you are somehow connected and that you're operating together? Because again, remember that the trademarks are there to protect the consumer. And under that, there's a famous trademark case from 1989. Toyota was introducing their new luxury brand Lexus. And since like the 1960s, there was a company, LexisNexis, that produced this huge database of legal cases called Lexis. So Toyota develops this new company, Lexus, and they, of course, knew about the company Lexus that was used by lawyers. And the Lexus, the trademark holder, sued Toyota, trying to assert trademark infringement. Now, in this case, you had basically the same word in different spelling. From two different companies, and they actually looked at the different factors to determine if there was a substantial likelihood of confusion: the similarity of the marks, the similarity of the products covered by the marks, the sophistication of the consumers, the predatory intent, renowned senior mark, and the renown of the junior mark. In this particular case, you had a similar mark, you didn't have similar products, but more than that, the courts leaned on the concept of the sophistication of the consumers, in particular, the sophistication of the consumers of the Lexis legal database system. They said these are lawyers, they're going to be able to distinguish the two products. They're not going to assume that a company that makes a legal database is making cars, and vice versa. Like this wouldn't be enough to establish the likelihood of confusion. I can almost guarantee you, had Toyota been creating a legal database or providing some sort of legal services that were affiliated, that probably would have been a trademark infringement. And this is a good example. Over the years, Lexus, the car company, now is much better known than Lexus, the database, even though they're still around. The Toyota, the brand Lexus is so well known as a luxury brand of automobiles. They would now be the majority owner of the name Lexus. So they would have their own trademark disputes. If somebody was to start another company that had nothing to do with cars, they would probably bring an action, just because now you're dealing with a car company and not a niche market like a legal database. Now there's another relevant issue when it comes to trademark infringement called trade dress. Trade dress is the concept of your products all look and feel a certain way. And you know, a good example of this is Fridays, right? The restaurant Fridays, that the people have those particular uniforms, the color schemes, and everything like that, and they wear those buttons. Um, all of that together, not individually, but all that together creates the illusion of a coherent brand. And in Texas area, there was this company called Taco Cabana, and they originally had this franchisee that opened several restaurants, and then there was a deal that fell through, and so he opens Two Pesos Tacos that basically looked and just like a Taco Cabana. And what the court said is, you know, you have too many similarities. And in this particular case, I've actually been to a Taco Cabana. Part of their shtick is that they have outside furniture indoors, as reference to the fact that it opened as originally as a taco stand, and they have like, you know, a certain type of color scheme and that sort of thing. So when you would walk into the Two Pesos Tacos, you were like, is this the same restaurant? You know, because that sort of feeling. And basically, this went all the way to the Supreme Court, and they said that a business owner that copies trade dress may be seen as falsely claiming that his products, for some reason, are thought to have originated from the plaintiff. And that's really what I'm talking about. Like, there was an undeniable association between the two. They were both selling tacos, very similar menu. You know, both were using the same types of furniture and color schemes. And so then they said that this, you know, that there was infringement of the trade dress. And you can even see, at least from the outside, they've changed the color scheme somewhat, but between the two restaurants, they would look the same. Like, you know, in totality, it was creating this false affiliation, and ultimately Taco Cabana won. And as a result of this lawsuit, they actually ended up buying Two Pesos Tacos out. So, and I found this particularly interesting because this nearly the same situation occurred in Cleveland area with Barrio Taco and Condado's Taco. The first time I had been to Barrio several times, and the first time that I went to a Condado's Taco was in Columbus. And I go in and I'm like scratching my head. I'm like, I feel like I've been here before. You know, they use a very similar scheme, and it it turned out after looking it up that what happened was Condado's Tacos was actually opened by one of the original founders or original partners of Barrio Taco, and wasn't happy with the business arrangement and decided to go off on their own and open Condado's Taco. And they basically had them operate the same way, where you were, you know, you order your tacos, like if you want steak, lettuce, and whatever on this piece of paper and turn it in. Now, when Barrio originally they just agreed to operate in different markets, but then of course that doesn't last forever as the idea takes off. And Barrio eventually brings a case of trade dress infringement against Condado's Tacos. And really, what the court said here was not so much that there wasn't trademark infringement. They were said, or there wasn't a copy of the trade dress. It says they basically Condado's or Barrio didn't have enough to establish a trade dress. They acknowledged the similarities, but they just said that there were too many things that Barrio did that was generic sounding, that anybody that was part of the public domain. The name was not distinctive, as apparently there were several other restaurants that have that name. The Day of the Dead decorations that Barrio used is they're very common in Mexican restaurants. Barrio used black and white, while Condado's used a pastel color scheme. There was different signage. And the remaining similarities, foil wrapped food, mason jars serving drinks in order forms, they were not unique to Barrio. Basically, they just said Barrio didn't have enough uniqueness in order to have a trade dress to infringe. And that was actually interesting because, like, to me, it was right on the border of if there was enough, especially because when I went into the second one, I'm like, there's got to be some sort of story here. And they said that, like, basically to have a trademark through trade dress, it has to be unquestionably associated with one company. You can't pick a bunch of generic components and expect it to turn into a trade dress, at least not until your company's more mature. So that was, so we actually had both in Texas, a taco company that found trade dress, and in Ohio, we had another taco company that found no trade dress infringement. So that kind of an interesting situation. Now, I want to talk real quick about genericized trademarks. This is all the problem that everybody wishes they had. If your trademark is too powerful and too well known, eventually you can actually lose your trademark. It becomes a generic word. And by far the most famous famous one of these is thermos. When King Sealy originally created the thermos, and they referred to it as a vacuum bottle. And then there was another company with Aladdin Industries that created a thermos because that's what people called them. And of course, originally the court just said, like, look, thermos is so well known, nobody uses the word vacuum bottle. So, the word is generic and anybody's allowed to use it. But they said that King Sealy was allowed to use the circle R and use the capitalized word of like original thermos, and nobody else was allowed to use that. So this is kind of the catch-22, is that you want your brand to be successful, but not so successful that you lose your trademark. Again, it's not really an issue that you're going to encounter, and if you do encounter it, you're very successful, but it's still an interesting one. And here's a list of generic trademarks over the years: trampoline, dry ice, escalator. A couple of these I did not know had originated from trademarks. And then relatively recently, last couple of years, Taco Tuesday, I think was originally registered by Del Taco, and it got released to the public domain. I always think at some point the word blizzard in reference to the Dairy Queen sundae is going to become genericized, because practically everybody has a ripoff name of it: the McFlurry, a whiteout, a wizard. When I've given this presentation in the past, I always say, well, I don't know any other word to describe this other than it's like a blizzard. Somebody said that it could be a concrete mixer, and I looked up concrete mixer, and that refers, as far as I can tell, 100% of the time to the use of frozen custard. And you know, if you're a fat boy like me, I would never confuse frozen custard for ice cream. They are two completely distinct indulgences, and I would never use the term concrete mixer to describe a blizzard, simply because I would always assume it has frozen custard, which I'm not real crazy about. So I think I do not believe that there is a generic term for blizzard. You'd have to describe it as a soft serve candy mix-in, and nobody's going to use that. So at some point, Dairy Queen may lose their trademark on the word blizzard, but who knows? So that concludes trademark, and let's move on to copyright. Copyright covers original works, computer code, advertisements, films, podcasts, technical drawings, artistic works. Unlike other areas of IP, you don't have to register copyright ever to get it protected. You just create it and it exists. And the reason for that rule is because copyrights are just created all day, every day by certain people. And if the Copyright Office required you to register them all, nothing would get done. Instead, you only have to register it if you're going to sue somebody for copyright infringement. We'll get to that in a second. One of the bigger issues with copyright is the fair use doctrine, and we'll cover some of that in detail. But fair use allows you to use like the name of something. Like, for instance, if I refer to the Cincinnati Bengals or the Cleveland Browns, and I'm just talking about the team and don't use their logos or don't show any footage of a game, I'm allowed to reference them because that's the name of the organization. And the fair use doctrine covers a lot of situations where you can use parodies and that sort of thing. And I have a picture here of Under Pressure because Vanilla Ice in the early 90s created Ice Ice Baby, and it used the same riff from Under Pressure, and it was clearly a derivative work. Now, very common in the music industry to pay a license in that sort of situation, but that's a good example of like covered under the same copyright, and one is a derivative work of the other because it clearly was using the same original riff that Under Pressure used. So you get the question similar to trademark: do you need to register? And the registration in copyright, really the advantage is it provides you the evidence that you own it. You can establish that evidence other means, creating PDFs that are timestamps, sending emails, that sort of thing that show that you owned it. Alternatively, when you register it with the Copyright Office, it definitely establishes that you owned it or that you had it in your possession at a particular time. But you don't need to register it unless you're going to bring an infringement action. A lot of times, big registers of copyrights are photographers. They take lots of pictures. They actually have software that will automatically upload their albums to the Copyright Office and fill out the paperwork to register them, just because they have to do thousands and thousands of pictures in a given year. Another question that I get a lot of are comments about employee created works called work for hire. Basically, if an employee creates a work, like they computer code or whatever, or takes a picture, it's presumed to have been authored by the employer for copyright purposes. Where we get a lot of issues is the fact that a lot of people confuse this for work hired by contract. Work under contract is not the same as done by your employee. If you contract, like a photographer or something, you do not own the work that they've done. This is the same, like this issue comes up a lot with tattoos, actually. If you hire a tattoo artist to give you a tattoo, you're actually contracting for that tattoo on your arm. You do not own that design. That tattoo artist still owns the design, and you can't then go and start copying that design and putting it on other people's arms. The tattoo artist still maintains that. You can create a contract that gives you those rights. It gives you those rights through negotiation of the contract. But if you, by default, if you hire a contractor and they're not your employee, then the contractor maintains the rights to the copyright. And it's very, very important, because I get that question a lot of times. People think they did an employer created right, and you don't have an employer-employee relationship. So let's talk about a couple examples of copyright infringement. And as you can see here, you have to have a substantial similarity, sometimes called strikingly similar, to the copyrighted work. And this Kerr versus New York Magazine situation was in sometime in the 80s. Kerr created this image on the left of this mohawk of New York City, along with a goatee. And then the New Yorker produced this magazine front page with this green individual with a mohawk that was the same skyline. And basically, Kerr tried to show evidence that this was an infringing work because they tried to show evidence of how the artist was able to derive this, and tried to show several instances where the artist had seen this work, and so it had clearly been inspired. And the court said you can't just show like circumstantial evidence where the infringer might have known about the infringing work. It has to be a clear copy. And they basically said there were too many differences between these two images. One was trying to show more edgy mean look, and one was with color, creating a more serene message from the artist. And as a result, it just wasn't enough to be a derivative work, and therefore there was no copyright infringement. One of the other things to look at is how you can detect copyright infringement, because in this particular instance, there was only circumstantial evidence that the artist on the right had even been aware of the image on the left. And so one of the tricks that they've come up with, or they came up with a long time ago, was fictitious entries, referenced often as paper towns. They even made a movie that talked about this issue. And basically, a paper town was in the time when cartography was still a popular trade. Cartographers would put fake towns somewhere randomly in the map that didn't exist in the real world and just had a name in them. And then when another map would come out and it would have that same fake name, that fake town, a paper town, it was really good evidence that that map had been copied from the other work. Because otherwise, why would it be the same? That town did not exist otherwise, and that really that type of evidence there is a big difference between, they might have seen this, they might have been aware of it, and no, this clearly had to have been a copy. And then, of course, there's the situations where there's an obvious or crude attempt to create this similarity. If you've seen the movie Coming to America from the 80s, they had McDowell's, which was obviously McDonald's, or the Buy More from the TV show Chuck, which was obviously Best Buy. And in those type of areas, there actually was no infringement because those were both parodies, which is protected fair use. But had real companies come in and bend those two things, they almost certainly would have been seen as infringing. So let's talk about a time when there was copyright infringement. Interestingly enough, it also involved the New Yorker. So there's a famous picture on the left from the New Yorker. I believe it's called the New Yorker's view from 9th Avenue or something to that effect, where they were showing somebody that lives in New York City this message of, they have real detail in all of Manhattan, but as soon as you go over the Hudson River, like, there's very, very little detail, and it just kind of, it's over the river. A lot of New Yorkers allegedly have this view. Well, later in the 80s, this movie Moscow on the Hudson came out, and they used the image on the right as their poster for the movie. And as you can see, they were basically trying to convey the same message. And so Steinberg versus Columbia Pictures came in, and basically the courts ruled these are clearly connected. And the image on the right is clearly trying to convey the same message. Even though there are differences, the one on the right is clearly a copy of the one on the left. And then, interestingly enough, the Columbia Pictures tried to argue, well, it's a parody. And the court said, well, they're both parodies, right? But the one on the right isn't a parody of the original drawing. It's just a parody of how New Yorkers view the world. So, you can't get the fair use doctrine by just having being able to claim it in that instance when you're clearly using it for commercial purposes to promote this picture and trying to send the same message as the original work. So this case, there was copyright infringement, and they said that there was a derivative work. So another example of a situation in of a paper town came from like 35 years ago, or closer to 40 now. And basically, the origin story of how we got PK zip. Everybody knows a zip file. So originally, there was this company called C that created the .arc compression format. And Phil Katz worked for C originally, and then started his own company, PKware. And he claimed to have recreated the .arc compression format, and they C took him to court, and they had some negotiations. And one of the things that came out in discovery was that Phil Katz's code was the same as the C code, including the comments in the code and the misspellings. So effectively, the equivalent to a modern version of the paper town. You wouldn't misspell the same word and use the same comments in code unless it had been a clear copy. And so they're determined that this was a derivative work. And as a result, Phil Katz actually created a new format, the .zip format, and PKware, and then developed, sold it as the PK zip format, and we still use that today. So that's originally how the zip file started. This next example has to have some background for how technical explanation of how how APIs work. APIs stand for Application Programming Interface. And what they are basically is a bunch of computer code that allows you to write a computer program that causes another computer program to do something. Think of it like, you can think of it as a remote control, if you will. And the analogy sometimes it's used is a waiter from a restaurant is the API. So the user tells the waiter what they want. The waiter then works in the kitchen, equivalent to the back office, comes back and gives the user what they were asking for. And that's really like what an API is doing, is that you have another computer program that's causing an end user computer program that's causing a back-end server operation, and then you don't actually see how the back-end server operation is working. All you see are the results. So a example that you might know of is Twilio. And in this instance, they have an API set up that allows you to send easy computer commands in computer programming to cause it to send text messages. So basically, the Twilio handles all the back end with the interface of the SMS messages and the formatting and all of that. And so you can just tell Twilio, I want to send a text message from a particular number to a particular number, and here's the message. And then Twilio confirms that the message was sent. And that's, it greatly simplifies the sending of SMS messages if you're a programmer, because you don't need to know the back end interface of how to work with cell phone companies. So why is that important? Because in 2021, there was a Supreme Court case about fair use when it came to computer programming called Google v. Oracle. Oracle had purchased Sun Microsystems, and Sun Microsystems had developed the Java programming language. And so when Google was developing the Android operating system, basically they wanted to use Java as the main programming language. But when they had negotiations with Sun, those negotiations broke down for whatever reason. But Google decided, well, we want to keep using Java, so we're going to create our own version of it. So what they did was they took the libraries for the Java and created the new backend called object code in order to have the commands, the API commands, do the same thing under the Google Java, if you will, that was done under the Sun or Oracle Java. So basically, they rewrote all of the backend work, and the front interface remained the same. And what the advantage of doing it this way is that Google didn't need then to train new programmers in a new language. They could just hire Java programmers. And the Supreme Court rambled on for 3 pages about what an API was. It was clear that that wasn't their specialty in computer programming. And they ruled that Google copied those lines of code, just the API language, not because of their creativity, their beauty, or even their sense, because of their purpose. It copied them because programmers already learned to program, to work with Java, and it would have been difficult to attract programmers to the Android system without them. And basically, they said that that was considered fair use because they had copied such a small portion of the code in the end. And basically, Justice Thomas dissented and said it makes it difficult to understand any or imagine any circumstances which declaring code would remain protected by copyright. This is a good example of a situation where I think they're clear on the facts, and I really disagreed with the Supreme Court on the ruling, especially for the reason that I highlighted there, that it allowed Google to basically hire programmers without training them, without developing anything, and get the benefit of Java without actually paying the license. And in my view, I would have gone the other direction on this ruling, but I don't get a vote. So this was a landmark case of fair use doctrine when it came to computer code. So if you have an API and you reprogram the back end of it, and you can use the same commands to do the same things on different servers, that is now considered fair use under this ruling. So it's a pretty important legal case for computer programming. So we're going to talk real briefly about trade secrets. It's kind of in the name. Basically, you can keep a trade secret forever, but you have to maintain that trade secret. And of course, you have the famous trade secrets of like Coca-Cola and KFC. New York Times bestseller list is also a trade secret of the algorithm they use to determine that. I've heard that the KFC recipe is actually, they have three different factories. They have one factory that does half the spices, another factory that does the other spices, and a third factory that mixes them. So none of the companies can see all of the ingredients that are going in. Really, a trade secret, you have to follow procedures in order to maintain the trade secret, a vault or something like that. And you have to try to stop data leaks and that sort of thing. If the problem with trade secrets is, number one, it's hard to prove that they exist, and number two, if they are leaked, and even if you have a trade secret, like let's suppose that you got the KFC recipe and posted it out there, you can stop trade secret, you can sue for trade secret infringement for the person that released it. But if somebody else uses it, you can't stop them. Like, it only really affects the party that violated the secret. It doesn't affect third parties that get that information from the data leak. So they have limited utility, but they're free. I mean, in the sense of IP, they're just a matter of protecting them, and you usually make sure they're in contracts with employees and that sort of thing to protect them. But that's sort of what they are. So let's talk then about my area of practice, patents. Patents cover either what a invention does or what it looks like. What an invention does is called a utility patent. What an invention looks like is called a design patent. And as you can see on the right, there's the game Simon Says from the 1970s, and that particular disc that they were selling, it didn't, this was a design patent. It just covered the way it looked, not the way that it operated. So you could have another game out there that would have done the same thing, but you would have had to use a different setup. It's important to understand that a patent gives you the right to exclude others from making and using your invention. It does not give you the right to make and use your invention. And it's really important to understand that just because you get a patent on a product doesn't mean you don't infringe on somebody else's product. You just means that you can stop somebody else from, doing the same thing. And sometimes that is an advantage because you can develop an enhancement for a patented device And then the company that has the patent for the original device might have to cross-license that from you in order to have the best version of that device, if you to have that enhancement. And so that actually can work to your favor if you know how to use it. So a utility patent, the infringement is a complicated situation that all patents end with a claim. And a claim has one or more elements. So, you could have, you think of a can would have a cylindrical body, a recessed area for the for opening the can, and the tab then that can create a lever to open the can. Those would be example of 3 elements in a claim. So each claim has a certain number of elements, and it's very important to understand that infringement requires that you have all of the elements of the claim. In order to have an infringing device, if you have elements A, B, and C, that infringing device also has to have A, B, and C. If they're missing one of those 3, they do not infringe. And I've gotten this question over the years, and I'm like, well, why are they allowed to rip you off? I'm like, well, they're not ripping you off. They're not infringing your product. You build a fence with particular parameters, right? And they built right across that fence, and you may not like it, but in the end, they didn't have a technicality. They had the rules of patent law is that you did not have all of the elements of the infringing device. So if you look here as this example, we have elements A, B, and C, and then in claim 2, we have element D. So it has claim 2 has elements A, B, and D, A, B, C, and D. So you have an infringing device that has elements A, B, C, D, E, F, G. You can have any number of elements. You have a million elements in this infringing device, but it has to have those 4. Now, in the second example, if you have an infringing device that has A, B, and C, but doesn't have D, you'd only infringe on claim 1. Now, you only need 1 claim, but you would not infringe on claim 2. We'll don't need to worry about the value of what we have claim 2 for purposes of this discussion. Just know that you only infringe one claim in that situation. A non-infringing device would have elements B and C only. It doesn't have claim, or it doesn't have A. Now it can have B, C, D, E, F, and G, and it still would not be infringing because it doesn't have A. The only thing that matters is, does it have all of the elements of the claim? Very, very important. So we'll cover an example, a real world example of that. Here, let me. I'm a woodworker, and sorry, I'm a woodworker, and there's a company out there called SawStop, and SawStop has this saw, and sometimes this video works, sometimes it doesn't. It's showing me this time's not really gonna work. But there's this hot dog, and you have this hot dog, or which could represent your finger, and the spinning blade. And when you
is made possible by a sophisticated.
So watch this.
But the concept is.
Now, as soon as the hot dog touches the blade drops below the table and doesn't cut off your finger. That's the intention of the whole thing, and it works fantastically well. Bosch released a competing product that did the same thing, but while the product in SawStop, what they did was actually hit the blade hits a brake and then pulls it below the table. Instead, what Bosch does is has a tiny explosion that's actually from airbags, because Bosch also makes airbags, and it forces the blade below the table and doesn't have a braking element that stops it instantly. Instead, it just spins for a second underneath the table. But as long as it's beneath the table, it still protects the user from cutting their hand or their finger off, which is, great safety devices. When the Bosch system was released, a lot of people on forums and stuff said, well, they're totally different. They operate completely different. The differences between the two systems were not relevant for the end products. You had to look at the patent. A patent does not require you make and use your invention. It just requires that you find somebody that's infringing on that product in order to stop them from making and using theirs. So basically, SolStop asserted they infringed 2 patents, a lot of other patents too, but just take a look at 2. And they had a work surface for defining a cutting region, like basically the top of the table, a cutting tool, the blade, a detection system, and a reaction system that's configured to retract the cutting tool below the work surface within approximately 14 milliseconds after a dangerous condition is detected. And then they had this other claim on a different patent that was similar, where they claimed the brake. They have a brake configured to stop the blade upon detection of the dangerous condition. See, the difference between these two was the only thing this claim required was that the cutting tool pull below the work surface within 14 milliseconds. It didn't say it had to have a brake. And this one said they had to have a brake. And as a result, Bosch did not infringe on this patent, but they did infringe on this one. And therefore, SolStop was able to bring an International Trade Commission, an ITC action against Bosch to stop them from importing this saw. And so Bosch only was able to sell the saw for about 6 months before it was taken off the market. So this is a good example of clear situation where you had infringement of one patent because it didn't specify how something was operating. It just specified it did it in a certain way within 14 milliseconds. In the second case, where you actually specified how it happened and the infringing device or alleged infringing device didn't have that. So there was the 2 differences. The last word we'll give here is about NDAs. You probably, as entrepreneurs, you've heard them in non-disclosure agreements. They get thrown around a lot, and you basically understanding NDA is not intellectual property. It's a contract that defines rights to intellectual property. It needs to define a remedy. It's not a replacement for IP. And one of the things I would caution you is to do not sign an NDA just blindly. Know why you're signing it. Know what you get from signing it. If you have to sign it in order to get a deal, for instance, and find out when the NDA expires. If you don't know those 3 things, don't sign it, because I see tons of situations where you have companies just ask for an NDA signed for everything because it's easy to ask, right? That's no skin off their back. But if you push back and say, well, I'm not going to sign an NDA because there's no benefit to me, a lot of times the companies won't require you to go through that, or they will sweeten the pot somehow. They'll either compensate you or at least clearly define when the NDA is going to expire. A lot of times they expire when a patent is filed. The NDAs are complicated sometimes for programming work because they prevent the disclosure of work to clients. But it doesn't mean that you necessarily have the IP rights. So what can happen is you require the programmer to sign an NDA, and that's all, right? So they can't, that programmer won't sell the code to another client, but that NDA didn't require any patent rights to be filed or be assigned. And as a result, nobody can get a patent on that in that instance. So in those cases where you have the NDA, should also specify that the company that hired them gets the patent rights, or that the company that did the programming gets the patent rights, but those need to be negotiated. So that's definitely, an issue that I see on occasion when it comes to NDAs. And because people just blindly sign these, and you really need to make sure that a particular contract that isn't always really clear to you what you get out of it, that you understand what you're signing. So that's what I've got. And now we have some time for some questions. So let me hit stop on the sharing.
We have a bunch of questions.
Okay.
Tom Root has said, 30 years ago, we recorded a cassette tape. We would like to reissue the recordings. However, the famous Detroit Tiger announcer narrated the tape. Can we use his voice on a re-release?
So that's a pretty fact-specific situation. And so what you'd have to know on the re-release is if it was an original work and you owned the original work, you could re-release the tape simply because you would already have the authorization to do so. for the person's name, image, and likeness. And unless the contract specified, the original contract specified that there was a limitation on that, then you would be able to re-release simply because you're just following the original terms that were set forth. And what you can't do in that situation particularly is change the recording with AI or something like that, because then you're using the name, image, likeness of the deceased in a way that was not licensed by his estate. But if they've already given you permission to use that recording, then unless you had a contract in the back then that specified some limitation, then I would think that you'd be okay.
Okay. Do I need to display the TM symbol?
If you want to claim that anything is your trademark, that your name, your logo, your slogan, or the name of your company is a trademarked entity, then my advice is to put it everywhere that you put that thing that is trademarked. So if it's a logo, put the little superscript TM every time you use that trademark. And I don't know of an exception there might be exceptions where you don't have to, but I don't know of an exception where it's not good practice to constantly assert this is something that I own. That's basically what you're saying when you put the superscript TM. I own this and I have, I am controlling the use of this. And so every time you say that repeatedly gets, the listener hopefully will start to understand and associate that product with you.
Okay. Is it worth filing an intent to use to protect the new company name before use in commerce?
Is it? Technically, yes, but it's a matter of how much resource that you have. In what I see with entrepreneurs is that tends to be a little overkill because, as you mentioned, intent to use, you haven't even used the product, you're not making any money on it. And, if your company is successful and is bought by another company, which is very common, they're probably not going to use your trademark anyway. So I would try to say, test the market first. If you have strong resources and you're a well-funded company, absolutely do the intent to use trademark ahead of time, because it can provide you some legal advantages. But if you're operating on a shoestring budget, and a lot of us are, you can just spend your money elsewhere. It's no perfect answer there, but it's really a balance of how much resources you have to develop this brand versus how much sweat equity you have and lack of financial resources that you have for everything else, and trying to split hairs here.
If you have an idea for an app, how can you protect the idea, or do you have to have the full app developed? If you use a consultant to define the app for you, is it your IP or theirs?
Okay, so in general, you need to have a description that could allow someone of what they call ordinary skill in the art to make and use the invention. And so with computer programming, the big issue is, do you show enough that shows the algorithm or how it's operating at a low level, not necessarily with the code, but like flow diagrams and that sort of thing, that if a skilled computer programmer saw it, they would easily be able to reduce it to practice. And the concept of, would they be able to write the code to do what this asking. The second part of that question that I covered a little bit, and I'll go into a little more detail, is when you hire a programmer to do something, it's a contract. And it's very important that you understand that a lot of times there are co-inventors. Like if you tell a programmer to go write you code of an idea that you have, but in order to implement that idea, there's some real inventive parts to it, then both you and the programmer are both co-inventors. And that way, and the reason why that's important is that needs to be spelled out in the contract of the work contracted out. Specify who owns the patent. Is it going to be the programmer if there's invention that's there, or is it going to be the one that did the hiring? And both are okay answers, because you should negotiate that point. If the programmer gets to keep the patent, for instance, then the work should be cheaper because they can reuse it later. Whereas if you get the patent, you can expect that the programmer is going to want a premium for that because it's a one-off time. They can never reuse that code unless they pay you a license. So so it is a point of negotiation, but the default rule is if you don't specify that in a contract, then the programmer could still be an inventor, but just because you gave them the idea might make you an inventor. And if you two can't agree that you are both inventors, then maybe nobody gets a patent because you can't agree on who should be named the inventors on the patent application.
Okay, should the name of your business have the trademark symbol in an email signature as well?
Yes, anytime that you use it, like and you can look up on Microsoft of how to put use the superscript symbol, but yes, use it in a. The big thing is every time you put it out in commerce, you're providing further evidence that you own the trademark, which not only can help you grow its strength, but also help you register it later when somebody else tries to claim they have something similar. You're like, well, I'm already using this trademark and here's all my evidence for it. And you can show, especially when a third party is referencing your product, and say it's already well known that it's established, it's associated with me.
So how much does it cost to register a trademark?
It depends on the number of classes, but I would tell you that you probably shouldn't expect to get out of it for less than $1,000 per trademark. I work with one of my friends. She is a real small law firm. She's a solo practitioner, and she does about the cheapest trademark work that I know. So if you have a mentor, they could certainly get a hold of me as the subject matter expert, and I can make a referral to her. Because but yeah, you probably should expect to spend about $1,000 just as a rule of thumb. Might be more, might be less, depending on how much is covered by the trademark.
Okay, I've been using my brand name for 7 years now, never used the trademark symbol or trademarked it because I couldn't afford to. I have videos, business V cards, and a bunch of other stuff with it. Am I good for now?
I would tell you, as far as good for now, I don't know because I don't know if anybody's infringing, but starting today, going forward, all of your new materials, and if you can change the old materials, do it. Obviously videotape you can't change or something like that, but put that TM going forward, because then now you're still telling the world this is not a generic term. This is something that I own. The problem is if you don't do it long enough, then you're trying to assert that this is part of the public domain. Anybody can use it. Not a great argument, but it's one that certainly an infringer would use if you don't put that symbol out. So definitely start, if you've been using it for 7 years, and start on August 13th of 2025, start you putting the TM so you can think about registering it in the future.
Okay, when do we use the superscript C for copyright? Must something be legally copyrighted before using it?
The answer is no. You can put the superscript C anytime that you put original work on. And it basically the superscript C isn't nearly as important as the TM, simply because in order to bring an action, you're going to have to define what is copyrighted later anyway. In general, I usually tell people put it on like the front page of a document or something like that, and list the year that it's copyrighted. But that's all you have to do to establish the copyright, is put the circle C and in the year that that's copyrighted. If you're not bringing an action, that's usually enough. If you're creating a book or something, I definitely recommend you put it in PDF format, because that's a little bit harder or easier to prove that it hadn't been changed. If it becomes an action, but when you're at the point where you're going to publish a book or something like that, you're going to spend real money on it. That's when it's a good idea to think about registering it as a copyright with the Copyright Office.
Okay, how does AI change this area?
How does AI? That could be its own webinar. But in general, the thing to understand is AI can't be a creator, at least right now. We can't have it. It can't create copyrighted works. It can't create impatentable inventions. Those have to be done by humans. It doesn't mean the human didn't use AI to do certain things in it, but the AI cannot be the named inventor or the named creator of the copyrighted or patented work. It has to be a human. Effectively, the long and short of it is our legal system has not caught up with AI, to say the least. Basically, there's a bunch of issues up in the air. One of the things I like to point out to people is if you go to an art museum or you sell art to anyone, right? There's an implied license that somebody looking at the picture is allowed to look at it, right? They're allowed to be inspired by it. They're not allowed to create a derivative work, but they're allowed to be inspired by, the techniques and that sort of thing. As a really lousy amateur artist, I can tell you that it's very common to do what they call a master study, where you actually take a painting and you recreate that painting, often with only like 3 colors or something like that, because you're trying to get the shapes of it. That's literally how they teach you art, or at least how I've learned by taking some online classes. There's an implied license when you sell art that you're allowing to do that. And what really it comes down to is the law hasn't caught up with the fact that there was no implied license for somebody to take that same image and feed it to a computer in order to train an AI model. That wasn't part of the deal. And at the same time, the copyright law is completely silent on this issue. At some point, Congress will need to update copyright and patent law and every other area of intellectual property to deal with the impact of AI. When is that going to happen? As I like to point out, Congress can't agree on what to order on a pizza. So I wouldn't hold my breath for them saving you. But the bottom line is the law is behind AI, and for now, the best I can tell you is that you can't have an AI engine be the named creator of intellectual property for either a patent or a trademark.
Okay, I own the trademark to my business. However, I just found out there are a few other companies with the same name. What's the best way to address them without going legal first, or do I need to go legal right away?
Well, the first thing is, if you're going to try to, quote unquote, go legal, I assume you mean bring an action against them. I would tell you, and independent of that, you need to have a registered trademark. And it really isn't clear on that comment. They said they have a trademark. As we mentioned, there's 2 types. That if you're going to bring an action, you definitely should have a registered trademark, just because it can at least establish that somebody else has considered the similar companies' names. So without going the legal route and bringing an action, what you can do yourself is, once you establish that you have the trademark, you can contact the owners of those other companies, or the decision makers, depending how large the companies are, and send them a letter stating that you own this trademark and you believe this trademark creates a confusion, and you're asking them to use a different mark. You can sometimes even suggest a new mark that that you wouldn't have a problem with. I remember like maybe 15 years ago, there was a video game called Guitar Hero. And somebody on the internet created a program called Piano Hero, which was operated in a similar way, and they actually got a trademark cease and desist letter from an attorney. But basically, they're saying, this is creating this substantial similarity issue, and the negotiation, because the defendant did not hire an attorney, just said, well, we're going to change the name of the program to, I believe it was Synthesia. And then the company that owned Guitar Hero was fine with that, and didn't pursue it further. So that is one way to handle that. Now, with the business owner that has the infringing product, they can ignore your request, and that honestly can be, as a common outcome. And at that point, you would have to contact an attorney if you wanted to go further, because you probably would need to bring an action. And it doesn't necessarily have to be a long drawn out situation, but just sometimes a threat of a lawsuit that you're really serious about this and you're no longer just sending a nice letter asking, you're going to insist. That can, help negotiations. It just depends on how strong and then if they want to fight back, it'll depend on how strong your trademark is versus how strong their business name is.
Okay, last question. If we are using public domain photos with original scripting to carry a message, can we copyright the entire image, especially if we modify the picture, for example, changing a black and white photo to color?
Yes, because it you have to establish in that scenario that your new version is more than a derivative work of the original. So it's actually it's sort of like you have to look at it. Would your new image be an infringer off the original image? Even though the original image can't be infringed because it was part of public domain. But that would be the standard there. So you look at, would your new image be an infringer of the original image? And if it would be an infringer if they had a copyright on it, then you typically don't have enough change in order to have created the copyright. But if you change it enough that it wouldn't be an infringer, then you have an original work that is just that was inspired by, but not a derivative from the black and white photo in that example. And then you would be able to protect it by copyright. So that's really I guess the crux of when did you do enough creativity in order to get a copyright? It's like, well, you have to create something that isn't a derivative work. Rather, that work is copyrighted or not. That's the standard of can you get your own copyright?
Okay, well, Michael, thank you so much. You've added a lot of information and answered a lot of questions, and I hope that those of you who have attended have found it worthwhile. We will be sending out a survey, and please give us your feedback. So enjoy the rest of your day, and Michael, thank you again.
Yeah, thanks for having me. And just out to the audience there, a couple of things on that. The feedback, if in addition to the review of it, if you have suggestions for particular parts of intellectual property that you would like a separate webinar on, include that in the feedback as well, because we could always set up a webinar that covers just one of the 4 areas if there was enough interest in any of those. So just keep that in mind, and hopefully everyone got something out of this.
Okay, well, thank you again.